Sale of land. A contract for a sale of land is an agreement to convey interest in land. There are two ways of selling land in Nigeria: A, under the customary law; B, under the received English law. Under the received English law, the applicable laws are Statute of Frauds Act 1677, Law Reform Contract Act, Conveyancing Act 1882, Property and Conveyancing Law, and the Land Use Act 2004. Restriction on sale of land: 1. Legislative restrictions. 2. Contractual restrictions. The main restriction under the legislative category is the requirement of the governor's consent as provided by Section 22 and 26 of the Land Use Act. The governor cannot grant a statutory right of occupancy to a person under the age of 21 years. Section 7 of the Land Use Act. Where a guardian or trustee acts on behalf of the minor, a statutory right of occupancy may be granted to the guardian or trustee on behalf of the minor. A non-Nigerian cannot be granted the right of occupancy or have a right of occupancy transferred to him except with the approval of the National Council of States. Section 46 of 1 of the Land Use Act. Some legislations prescribe that there must be obtained the prior consent of the minister in charge of an authority or department before there can be a transfer of interest in property held and owned by that authority or department. A good example is the Nigerian Coal Authority Act, Cap N 95 LFN 2004, which provides that the corporation shall not alienate, demise, mortgage, or charge any land vested in corporation without the prior approval of the minister. Town planning laws and regulations may restrict the alienation of certain lands where the purposes for which they are intended to be used are contrary to the purposes of town planning laws. A land situated in an area designated for residential purposes cannot be alienated for commercial purposes. Doctrine of lis pendens. The proper translation of this Latin maxim is pending lawsuit. The doctrine is geared towards the preservation of the land that is subject matter of litigation so that there can be no transfer of interest of the said land during dependency of the said action in court. Conditions where the doctrine of lis pendens will apply are: 1. There is a pending action in respect of the property. 2. The pending action is in respect of real property. 3. The action is for recovery or assertion of title to a specific property. 4. The party concerned was aware or ought to be aware of the pending lawsuit. Very important: a person who purchases a property subject matter of litigation for valuable consideration and without actual notice cannot sustain his purchase. Contractual restrictions include mainly covenants in leases. Usually in a lease, it is typical to have a covenant not to reassign or sublet or otherwise part with possession on the part of the lessee. Where the land in question is communal or family land, the consent of the family members and heads of the community or family must be had and obtained before there can be valid sale of the property. Adeleke and Ayonda 2001, 13 Nigerian Law Report, part 729 and page 1. Stages in conveyance of land: 1. Contract stage. 2. Conveyancing stage. Conveyancing stage is further divided into the completion stage and the post-completion stage. The contract stage: this is the first stage and it involves preliminary inquiries, deducing titles, investigation of titles, requisition of titles, and exchange of contract. Conveyance stage: this is the second stage and it entails the preparation of deed of conveyance, handing over of original title, perfection of title by obtaining consent, stamping, and registration. Under the common law, alienation of interest in land must be preceded by a contract for the sale of the land. The document which will surface at the first stage is the agreement to convey, and at the second stage, it is the deed of conveyance. At the first stage, the purchaser acquires an equitable interest, whereas at the completion stage, the purchaser acquires legal title to the property. Applicable laws: the contract for a sale of land in Nigeria is governed by Section 4 of the Statute of Fraud Act 1677 and Section 67 sub 1 of the Property and Conveyancing Law. The provisions of these laws combined is to the effect that a contract for a sale of land must be in writing. Thus, there must be a memorandum evidencing the terms of agreement of the parties. It is pertinent to note that Section 4 of the Statute of Frauds Act 1677 does not apply to land transactions under the customary law, Alake and Awawu 11 NLR 39 and 40. Where the writing requirement applies, the memorandum of sale must contain the 3 P's. The 3 P's are the parties, the property, the price, and in addition, the signature of the vendor. Types of contract for the sale of land: 1. Oral contract. 2. Open contract. And 3. Formal contract.